please.
Well, good afternoon, everyone. According to my computer, it's now 2 o'clock. I'm now visible to myself and therefore presumably to everyone else. Just a couple of things. Mr. Sweeting, your submission has been extremely helpful today. They require quite intensive noting. So can you just go a little bit more slowly, at least when you're going through, as it were, legal propositions? Obviously, it depends slightly what part of your, what kind of submissions you're on. Secondly, it is really very hot, at least for some of us. Where you are, Mr. Sweeting, looks as if it might be an air-conditioned office, but we don't all have that luxury. So we will have a break at a convenient time mid-afternoon.
Well, thank you. Yes, we are in comparative air-conditioned luxury here, so not the same problem.
Yes.
Well, prior to the lunch adjournment, I think I got to the point where I had said that one approach to this, and the one we really urge upon the court, is to say that we have reached the position where Roberts simply doesn't apply, because the parameters within which it was meant to operate simply no longer exist. And that is, we would say, almost certainly the conclusion the court should come to in our submission, given the move to a negative discount rate. So the way in which we would characterise the approach in Roberts and Johnson is to say that what the courts were doing was to endorse a methodology which operated in the circumstances in which the problem which was being addressed arose, but the court did not mandate its use in very different circumstances, in particular where it would lead to an absurd conclusion. And the methodology was in any event under strain in recent years, whilst there was some proportionate relationship between unallocated damage, and by that I principally mean damages for pain, suffering and loss of amenity, and the shortfall produced by the Roberts calculation, the approach was pragmatically workable, irrespective of whether, as a matter of principle, one thinks that a claimant should or should not have to use unallocated damages for the purpose of bridging the gap. In practice, it was at least possible, as the circumstances of the earlier cases demonstrate. I think we've made that point, as have the other parties in their submissions, that the gap itself fell within what could realistically be bridged with those unallocated pots of damages. Now, in more recent times, it has undoubtedly ceased to be the case that that possibility of a pragmatic operation of the methodology would continue to provide a solution. Now, it's difficult, in fact, to improve upon the way in which the learned judge at first instance put this in giving permission to appeal. She was, of course, just identifying issues rather than indicating a particular view, because she had reached the conclusion that she didn't have an alternative mechanism available to her. But we cited in the skeleton, actually, at paragraph 2.3. And what she said was, even if the current discount rate were to increase, the application of the formula produced anomalous results, even when the discount rate was 2.5%, to include scenarios in which the shortfall between the damages awarded and the sum needed to fund the property may be so great that the property could not be purchased. She went on to say there is a real issue now as to whether the formula remains fair and fit for purpose in the current economic climate of high housing prices, low interest rates, and the use of PPOs for the delivery of damages for care. All of those being factors which have come to the fore since the initial decision in Roberts and indeed since Wales. And in fact, this court itself has recognised the emergence of that problem, most notably in the judgment of Lord Justice Tomlinson in the Manor case. Again, it may be I should just read the portion of that case which we say is central. It's in the authorities tab at bundle 2, tab 31 at 789. Lord Justice Tomlinson said this: "The exercise in which the court is thus engaged is, in modern conditions, increasingly artificial. The assumption underlying the approach is that the claimant will be able to fund the capital acquisition out of the sums awarded under rubrics other than accommodation. But in modern times, residential property prices have increased rapidly, while general awards for pain, suffering, and loss of amenity have remained at their traditional levels." And that echoes what has been fairly cogent academic criticism and investigations into potential alternatives to Roberts and Johnston, which we summarise as part of the background in the written skeleton argument. Of course, whilst discount rates were at least positive, the fact that that gap was opening up produced a position in which it was becoming increasingly unfair and, as the learned judge said, potentially not fit for purpose. But it did not reach the extreme that was arrived at when discount rates became negative. In other words, that no damages at all resulted from the application of the formula. So, as I suggested a moment ago, our primary approach to this is to say that it is now evident that the methodology in Roberts is unworkable, not fit for purpose, defunct. It doesn't really matter what epithet one applies to it, but it was simply not designed to operate in the present circumstances, and the best evidence of that is that it doesn't, because it produces an unjust and absurd result. That leaves, I think, nevertheless, the necessity to look at the position in Wells, because the respondent certainly says that this court is bound by its own decision and also is bound by the decisions of the House of Lords in Wales, particularly that the discount rate should be accepted and used in relation to the Roberts and Johnston calculation. Of course, it was accepted in that case that Roberts and Johnston formed the correct or only basis for assessing damages relating to the purchase of special accommodation. So our starting point is that the House of Lords did not itself revisit and determine that that was the case. It was the case brought to them on an assumed and agreed basis by the parties.
So just putting that into formality, are you saying that it is not a matter of ratio?
That Roberts was the only or even the correct approach to the calculation of damages for the purchase of special accommodation.
Because I can't remember, I ought to know this backwards, but in a situation where a legal proposition forms part of the reasoning of the court, but was not the subject of dispute before them, is that ratio?
Well, it leaves the matter open for argument, unless in the course of giving the judgment it is accepted as a proposition of law which is necessary for the decision which the court eventually arrives at.
Well, let's see what they say anyway. Yeah.
So, Lord, if we turn to Wells, which is tab 16 in the first bundle.
Yeah.
This was a conjoined appeal, Wells and Thomas and Brighton, often referred to as Thomas as well, but I'm just going to refer to the case as Wells. Lord, it may be that one doesn't need to set out in any detail what the particular point of the case was. It's adequately summarised in the head note. Each of the three cases in which the defendants had admitted liability for causing serious personal injury.
I'm not sure you need.
I'm obliged.
Would you like to read us the whole of the
No, I'm just going to read the first sentence, in fact.
Okay, right, carry on then.
Were calculated by the trial judge on the basis that the capital sum awarded would be invested in index-linked government securities, producing a net return. And the issue was about, in effect, what rates of return ought to be adopted. Well, I'm going to take you, I think, to what I suggest are the references in Wales which really indicate the approach that the court was taking, the House of Lords was taking, to the Roberts calculation, and in particular to whether it was really simply a guideline methodology or whether it was setting out some principle of law on the declaratory basis, I suppose, of precedent that one is extracting from the thickets of other cases some principle of law which has always been thus. We say it's the former, but effectively these were guidelines which the court was considering. If we turn firstly, and I'll simply do them in the order in which they appear in the judgments, if I may, to page 326 in the bundle. Speech of Lord Lloyd. He refers under the heading Guidelines to section 1 of the 1996 Act. I'm going to go to that separately in due course, but you'll see that section 1 of the Act says, in determining the return to be expected from the investment of a sum awarded as damages for future pecuniary loss, and then in effect the discount rate set by the Lord Chancellor is the rate to be used. Came into force on the 24th of September 1996. At that stage no rate had been set. And then at E, in the meantime, it is for your lordships to set guidelines to replace the old 4 to 5% bracket. There is something to be said for a bracket, since it allows some flexibility in exceptional cases, as where, for example, the impact of high rate tax would result in substantial undercompensation. The award of 2 million high rate tax payable over the first half of the 20-year period would alone amount to nearly 75,000, but the majority of your lordships prefer a single figure. I do not disagree, provided it is subject to the same flexibility as is to be found in section 1(2) of the Act. In other words, there could be a departure in exceptional circumstances. And then at the foot of the page, letter H, it's undesirable that the guideline should be changed too often. And we say that's advisedly a reference to guidelines at that point.
Just remind me, why does he say the old 4 to 5% bracket needs to be replaced? It's not because of the legislation, because the Secretary, the Lord Chancellor, not at that point specified a rate. So why did somewhere earlier on in the judgment he has said why they had to be 4 to 5%?
Yes, well, that was because of the earlier cases were pinned to the mortgage rate.
Sorry when you had prepared to do this, but if you could just now or later,
yes, certainly,
point to why he takes that for granted. Okay, so that's where he starts. They're not be replaced. Yeah.
And so we had guidelines at the foot of the page. If we turn on to page 333 in the bundle,
yep,
maybe an answer to the question. In fact, this is called Stain, the conventional rate of B, settled practice endorsed by decisions of the House that the lump sum to be awarded for the present value of a plaintiff's future loss of earnings and present cost to his future expenses ought to be determined by using in the calculations a discount rate of 4 to 5%. There's no other practicable basis of calculation. And then the question before the House is whether this practice should now be modified in changed economic circumstances by adopting a discount figure assessed by reference to index-linked government securities, the suggested figure being 3%. if we go on to 339, further on, with stated speech, we again have a heading at G, the guideline. Until the Lord Chancellor takes action under his statutory powers, it's essential that there should be a firm and workable principle, should be general and simple, in order to enable settlement negotiations and litigation to be conducted with the benefit of a reasonable degree of predictability of the likely outcome of a case. While acknowledging an element of arbitrariness in any figure, I'm content to adopt about 3% as the best present net figure. For my part, I would derive that rate from the net average return of index-linked government securities over the past 3 years. This figure of about 3% should not be regarded as immutable. I would suggest that only a marked change in economic circumstances should entitle any party to reopen the debate in advance of a decision by the Lord Chancellor. And Lord, we make the point that the court was looking at this in terms of a rate and an approach to the exercise it was conducting, which took into account economic circumstances and specifically regarded what it was doing as not setting out something which was immutable. That is perhaps even more explicitly set out at page 348 in the bundle, the speech of Lord Clyde. At the foot of the page at H, of course, such a formula should not be seen as set in stone. It can serve as a general guide, open to modification and adjustment to meet the demands of particular cases. I would favour a rate at the present time of 3% net.
Sorry to break in, you said page 348, but I think that might have been a...
Lord, it's 348 in the bundle, as I have it. It's 397 in the judgment in the law report itself.
Thanks, I'm very sorry for it.
So I was, as a matter of convention, just adopting the bundle of page references. And, Lord, just in case your Lordship hasn't caught up, it's at the foot of the page at H.
Yeah. Okay.
That's the portion that I've just read. Lord, finally, in relation to these references, I think Lord Hutton at page 355 in the bundle at the foot of the page at H, I further consider that in order to promote and facilitate settlements and to simplify the assessment of damages in actions which come on for trial, the rate of 3% taken by this House in the present appeals should be applied in other cases, notwithstanding fluctuations in the return on ILGS, until the Lord Chancellor prescribes a different rate pursuant to his power under Section 1 of the Damages Act, or unless there is a very considerable change in economic circumstances. There is support for this course in the judgment of the High Court of Australia and Tolerate.
I think it's coming back to me now. I'm sure there are many in this virtual room who know this much better than me. I think what was everyone agreed meant that it has been looked back at again was the introduction of what in those days we called granny bonds. Basically, index-linked stock.
Yes.
Unless that's wrong, no one need go on looking for the answer to my first question.
No. So, Lord, we say that the approach which was being set out in Wales was very much to approach this as a practical solution, which had to be set out as one which would be operable in the course of negotiations, settlements, and the life of the law in relation to personal injury damages and litigation. And that we see a number of references to guidelines and to rates being set which were not immutable and not set in stone. And it would be odd to regard this as some form of declaratory judgment which was setting out the way the law had always been. It doesn't appear to be anything of the sort. It appears to be an attempt to introduce a sensible guideline for the assessment of cases going forward. As far as the Damages Act itself is concerned, we got that in the third authorities bundle at tab 36.
Just before we leave that, Mr. Sweeting, it could be said, couldn't it, that all that the Lords were saying was not immutable was the rate. They weren't saying that the methodology could be revisited. You may say that's implicit, but we just need to spell it out.
Yes, Lord, I'm not going to go so far as to say that we have a clear statement that what was being referred to there was more than the rate, and that the methodology was being left untouched. But the point we make is that the methodology of Roberts and Johnson wasn't an issue. It was the case about the rate, and even in relation to the rate, we see what the court is concentrating on is the need for a pragmatic solution which could be applied case to case and indeed in the course of settlement negotiations. It was a very clear acknowledgement of what the necessity of a practical approach is in personal injury litigation. It could, of course, also, and I acknowledge this, be seen as holding the fort until the Lord Chancellor actually introduced a rate.
You want us to look at the Damages Act?
Yes. Well, it seems to me this is an appropriate point at which to do it, since that case was decided once the Damages Act had passed in 1996, but before the Lord Chancellor had in fact set a rate. 861 in the bundle. 1. In determining the return to be expected from the investment of a sum awarded as damages for future pecuniary loss in an action for personal injury.
So sorry, the way the printout we've got has a section A1 and a section 1. I'm not familiar with this convention. Which is the one, the relevant one at the relevant time?
It's A1 now is the point, but at the time it was 1, I think.
But there's no difference between the two in relevant respect.
No, for the purpose of the point I'm going to make, there isn't any difference. So in determining the return to be expected from the investment of a sum awarded as damages for future pecuniary loss in an action for personal injury, the court must, we'll see earlier that was shall, but must, subject to and in accordance with the rules of court made for the purposes of this section, take into account such rate of return, if any, as may from time to time be prescribed by an order made by the Lord Chancellor. And then subsection 1 does not, however, prevent the court taking a different rate of return into account if any party to the proceeding shows that it is more appropriate in the case in question. So,
sorry, Mr. Sweet, I'm going to just mention this. On 2 or 3 occasions, the most recent being just now, we've lost a couple of words in English. I'm sorry, let's be clear what it is.
yes.
But if it's possible, it's a question of you not looking directly at the mic. So can you bear that in mind?
I will do, certainly. Thank you.
Yeah, okay, well, we got that, yes.
My Lord, so you're reading what's in front of you, I hope. My Lord, 2 points about that. Firstly, this section is about damages for future pecuniary loss. Obviously, it's a slightly circular position in relation to Roberts and Johnson, because the methodology only turns the loss into a future pecuniary loss because that's the way in which the damages are characterised. In point of fact, what the claimant has to do is find that sum of money immediately. And that, of course, is one of the problems with the approach, that the loss, I suppose, as one would approach it as a layman, is that you have to find an additional 900,000, but because you're getting a loss which is calculated on a discounted basis, in other words, as if it were a future pecuniary loss of the income stream which you would get on having to invest that money, then it is a future pecuniary loss. But that is only because that is how Roberts and Johnson is characterising the loss of £900,000. So nothing in the section prevents the court from adopting a different methodology if the methodology which is being used to characterise the damages simply doesn't produce the right result. And the appellant is not asking the court to take a different rate of return into account. In other words, relying on exceptional circumstances which go to the discount rate. The appellant is saying Roberts and Johnson as a methodology which characterises the nature of the loss as a future pecuniary loss has ceased to operate. So what the court has to do is to set that methodology aside and return to the fundamental principle that the claimant is entitled to full compensation. The reason I mention this is because this is raised in the respondent's argument as an impediment to what the appellant is asking the court to do. In other words, that we are in some senses prohibited as a result of the Damages Act from coming to this court and asking for the court to address the issue, because we would be contravening the mandatory provisions of the Act, and we are not asking for a different rate of return to be taken into account. We are actually asking for a different approach to damages, because the present approach doesn't produce an answer which gives any compensation at all. So, Lord, if that is the position, we would say we've arrived at a point where it is open to your lordships and your ladyship to do what the common law has always done, which is to react to events and circumstances as they change, and there is no obstacle to the court doing that in this case. Indeed, it would be very surprising if, in the circumstances in which we now find ourselves, the common law was so ossified and lost so much of its power that it was incapable of coming up with a solution. One has in mind the words of Lord Gough in the Claimant-Benson case in 1999, when he said that the common law is a living system of law, reacting to new events and new ideas, and so capable of providing the citizens of this country with a system of practical justice relevant to the times in which they live. And of course, that's the position the common law has developed for centuries on the basis of principles introduced by and amended by judges. I think Lord Nicola said a similar thing in the Spectrum Plus case in 2005, when he said for centuries judges have been charged with the responsibility of keeping this law abreast of current social conditions and expectations. That is still the position. Continuing but limited development of the common law in this fashion is an integral part of the constitutional function of the judiciary. Had the judges not discharged this responsibility, the common law would be the same now as it was of King Henry II. So, my Lord, we do go back to our starting position that the fundamental proposition that the appellant seeks the court to implement is that she should be compensated in full, and no compensation at all cannot be that result if it is the only result which is produced by the application of the methodology in Roberts. That methodology simply doesn't apply to the circumstances in which the court now finds itself in relation to the calculation of the cost of special accommodation. that's what I was going to say. I just pause at that stage in relation to the question of whether the court is entitled to revisit Roberts and Johnson, really for the two reasons we've set out, that in fact there is a higher principle in play here, and that it is broken, not fit for purpose, and so on, and can't have been meant to apply. But in any event, on the basis that there's certainly no prohibition in terms of Wells and Wells on doing that, and in terms of this court's own decision in Roberts, then we would again rely on the fact that this has proved to be now an unworkable solution. And indeed, that was the position in the first instance, the two first instance judgments in the High Court, JR and Sheffield in this case, in which the courts have decided that there isn't a mechanism which can allow them to award a loss, to award compensation for the loss involved in special accommodation.
The logic of your position, not that this really matters, is actually they were unduly, if there are routes we can take, actually they could be taken in the first instance because they weren't bound by Roberts and Johnson either. I don't say that by way of any criticism, but I just want to spell out that that's actually inherent in the way you're putting the case.
My Lord, it is, and I'd address that directly. At first instance, I wasn't involved at first instance here, I was in the case of JR. That was the submission, and indeed I was in the case of Manor, that the court wasn't bound by Roberts and Johnston in terms of revisiting the formula, in effect, which is set out in this case, given that it was unworkable. The difficulty, and it's a pragmatic difficulty for first instance judges, is that, as we'll come on to, if you reach the position where that is accepted, the question then is, what do you do next? Where do you go? And one has to accept that that is a matter of evidence, and it's no use turning up and saying, well, this is broken, because the judge is entitled to say, well, what is the fix? And the difficulty is that the court has limited powers. The sort of solutions which might have offered themselves are not within the ability of the court to order in many cases, notwithstanding the analysis which has been undertaken by the Commission and so on. So that, but equally, claimants are in a bind, because it is very difficult to go in front of a master and obtain permission to obtain all of the evidence which has been obtained in this case.
Mr. Sweeting, I probably started a hair running. I honestly did not want to any criticism of the way this was run. It's all come up in a way that's all worked out in the end. I just wanted to make it clear in my own mind that the logic of your position was that first instance judges weren't bound either. I can see all the practical reasons why that didn't help in practice. But let's move on. I'm sorry I raised it.
No, not at all. Lord, I've over-egged that particular pudding, so I'm sorry about that. Lord, I mentioned the position of the court and its powers. Obviously, we start from the position that what the court can do in achieving full compensation is to either award damages as a lump sum, or now, following the coming into force of the Damages Act, in the form of periodical payments. And of course, the latter, the periodical payments, has removed from the lump sum calculation, in many cases of serious injury, the largest heads of damage, that is, the cost of care and case management going forward. That means, in fact, that the overall lump sum pot is diminished, and if one is looking for things to borrow from, robbing Peter to pay Paul, as Lord Justice Tomlinson put it in Manor, there is less to look to. But in any event, unallocated damages have long since ceased to cover the gap. So we suggest that the position really is that the court is left with, as a starting point, full capital value. Now, Lord, I don't want to as it were, stress the extent to which we rely on this. it's not entirely a fallback position, but we say it is the logical consequence of concluding that the court is faced with a choice between zero, i.e. no compensation at all, and the only quantification that there is of the loss to the claimant, and that is the capital value of purchasing the accommodation. So the way we would put it at present is that if there is no other viable mechanism available, that mechanism was hitherto Robertson Johnston for all of its failings, which produces some compensation. In other words, if the choice is between nothing or the full capital value of the purchase, then the court would be bound in compensating the claimant fully to award full capital value. So we say it would be the logical consequence of a position in which there was no alternative between no damages at all or giving the claimant all that was needed in order to purchase the accommodation. Now, it is, of course, obvious, and I acknowledge at once, that there are circumstances in which one can demonstrate, because you can take an extreme for the purpose of doing this, that giving the claimant the full capital value would appear to offend the principles of a just resolution of a case, taking into account to the extent that it's permissible the interests of the defendant as well as the claimant. So, for example, if there was a very short life expectancy case, a life expectancy of a few years only, and at the moment, under Robertson Johnson, the claimant would get nothing, but what the claimant was seeking was, for the sake of an example, £1 million for the purchase of a house. One might think that the purchase, £1 million being paid to the claimant, which was going to fund the purchase of a house, however necessary, for a life expectancy of only 2 years, would in itself be an unpalatable result. In other words, as between capital value and zero, we are looking at polar extremes. And to some extent, Robertson Johnson, identifying that there would be a windfall on the death of the claimant, is trying to, as it were, square that circle by mitigating the effect of the windfall to some extent. In practice, Robertson Johnston, even in its application, didn't prevent there being a windfall to the claimant's estate in many cases at the end of life. But well, that's our starting position on full capital value, that the court should...
Can I just be clear, I understand that last point?
Yeah.
If life expectancy, if the claimant died precisely in accordance with their life expectancy, which had been adopted for the purpose of damages, even then, Robertson Johnson, you're saying, might produce a windfall. Is that right? And if
yes.
So, just spell out why. I'm not saying
well,
wrong.
Because,
make sure I understood why.
Well, because at the end of life, there is still an asset, and that asset still passes to the claimant's estate, and the estate still has the windfall, and the calculation of the loss of return on investment, obviously by reference to the discount rate, which is assuming either ultra-safe or more recently safe investments, doesn't always, as it were, take away the gain in value of the house. And of course...
Yeah, but that's simply because it's a rough and ready measure. Conceptually, it's intended to wipe it out. The fact that it doesn't work out in principle is just one of those things, isn't it?
Well, I think the point I was making is that it doesn't work out in practice in many cases, rather than in principle. Because, of course, that's one of the reasons it's become...
Sorry, if I said principle, it was a slip of the tongue. I meant in practice. It's just one of those things, if you will. All these exercises we're doing for the future may produce overcompensation or undercompensation. This is simply a rather more sophisticated version of that fact of life.
Yeah, well, that's right. But, of course, characterising the loss as a loss of return on investment is, I mean, it's even apparent on the figures which have been used in this appeal, is different from trying to match any projection of what the increase in property prices would be. I mean, there is a difference between the two, potentially. That's the point. And one will never
just the inherent uncertainty. It's actually using a measure of something else.
It is. That's right. And the two don't naturally run together. And of course, one of the reasons why, as a matter of practice, it's become unworkable is that property prices have increased so much. And in fact, one of the themes, of course, in the cross-examination was, well, actually, you're much better off investing in property, aren't you? Well, that certainly may have been the position over a period of years hitherto. And indeed, I think the learned friend Mr. Alderman was saying, well, you're better, aren't you, investing in the property if we assume it's going to go the same way than you would be investing in safe investments. So, well, that's the reason why I say that. It may be a little bit of a sidetrack, and I chide myself for going off in that direction. But, my Lord, I was making, I think, the limited point as to what our position is in relation to full capital value. So we certainly don't abandon that. We say it is the logical alternative if there is no other way of achieving compensation for the claimant. Well, there are a number of solutions which the parties have agreed are unworkable, and those are in the second supplementary bundle. Might simply be worth looking at those at tab 9.
Mr. Sweeting, I think these have been reproduced in both sides' skeleton arguments.
Well, Lord, yes, I think we may not have set them out at quite such length, but wherever we find them, I think it may simply be worth just looking at what these are, and of course what potentially remains. So the first is a PPO to fund an interest-only mortgage for life, and of course that's something which has been, as it were, identified in some of the research and academic thinking about this and some of the investigations which have been done in relation to a potential solution. And I'm bound to say it's one that certainly at some stages has seemed very promising as an idea, because the court does, as one part of its armoury, have the ability to order periodical payments and to do so whatever the wishes of the parties are, if it's the right solution. But the difficulty which has been identified by all of the parties to this appeal is that there simply isn't a suitable mortgage product that could be identified and funded by a lifetime PPO. And you will recollect that some efforts were made at first instance to try and obtain some evidence about a mortgage, and the evidence which was obtained, and we're not pressing that upon the court at this stage, perhaps because it's been overtaken by events and argument, is that it was very difficult to get anything other than some indication. And the court does now have evidence in relation to the paucity, really, of mortgage alternatives, whether funded by PPO or otherwise. Secondly, a loan. And can I start by saying that a loan is, in fact, the ideal solution in many ways. One way of dealing with the problem posed by special accommodation might have been at an early stage to say, for example, that the claimant was entitled to the full cost of purchase unless the defendant made an offer which it had to be accepted really in reasonable mitigation, and the obvious contender for such an offer would have been a loan. The reality is the sort of developments which might perhaps have been anticipated, particularly on the part of institutional defendants, in answer to the conundrum posed by Roberts and Johnston, have simply not occurred. And the reason for that, we would suggest, is that the balance of advantage in the Roberts and Johnston calculation has been moving steadily in favour of defendants. Why offer anything else if the reality is that you would have to pay increasingly less as a proportion of the purchase price which the claimant was going to have to meet? And the difficulty, and it's been investigated, is that particularly the regulatory requirements around the giving of a loan now, business in itself, are such that, on the face of it, that simply couldn't be met by insurers and the NHS. And the other way of looking at it is that they could have put themselves in a position where they met the regulatory requirements, but they haven't done so, and there was no incentive to do so. But there's no doubt that a loan with a charge on the property, absent any of these difficulties, would be a sensible and a complete way of dealing with the position.
Mr. Sweeting, the last thing I want to do is revive something which nobody's arguing for. Not intending to do that. But can you just explain why it would have to be a loan? Could the situation not be that the defendant paid, but on terms imposed by the court, that there was a charge on the property? They paid once a property was identified. On terms, there would be a charge on the property for repayment at the end of the period. That wouldn't be a loan, it would be obeying a court order. So some of the regulatory difficulties would be avoided.
Well, I think if your lordship is postulating that the defendant simply pays damages, that doesn't give rise to those difficulties. But the next thing that has to go with, so whether it's a loan or not, an interest-free loan or whatever, what the expectation is, the defendant is going to get back the sum which it has paid as damages. So there is an issue straight away as to whether that really is the payment of damages on a once or for all basis, which of course has a benign tax treatment, or whether if there is going to be a repayment of that sum, because the charge would have to be in respect of that sum, then...
Yes, the charge will be in respect of that sum, or possibly, provided a certain formula could be built in, that sum plus the proportion of the capital appreciation attributable to the bit of the property that the defendant had paid for, if you follow me.
Well, that is a form, of course, of equitable co-ownership. So...
You say so, but I mean, is that a problem in itself? But I mean...
Well, my lord, our starting point on that is that there isn't actually power in the court to do that, which is why
that may be the answer, but I see that is another version under A.
I wonder if there is...
As I say, I'm being rather undisciplined because in circumstances where the parties aren't arguing for it, and I am not contemplating going behind the parties' agreement, perhaps I should say nothing. But because this is such an important area, I just really wanted for my own satisfaction to understand whether the problem was only the problem that it was expressed to be a loan. I'm not convinced that what I would describe would be a loan in terms of the which would be fall within the activities of the defendant or the insurer which were regulated. They would simply be paying a sum they had to pay, but the court gave them a benefit of uncertain value by effectively imposing some sort of trust, which it did in Hunts and Sellers, if you remember, in relation to sums received for payment of services which had actually been performed gratuitously by relatives.
I think the problem may be, if I can intervene, that in order to solve the quote windfall close quote problem, it can't be a loan, even an interest-free loan, because that doesn't solve the problem. If the return or the obligation upon death to return the money reflects the windfall, it has to be a charge on the property.
Yes.
Which carries all the practical difficulties of co-ownership, as well as the regulatory problems. If it was a personal loan, even if secured, then there would have to be some very interesting mechanism by which the return on that loan reflected the gain in interest net of cost on the property at sale. And that comes very close to a trust for sale in favour of the defendant.
Yes, I think there are other difficulties one could easily imagine, especially with a long period, that the claimant might want to change the property 2 or 3 times in the course of a lifetime.
Well,
and you would have most elaborate, no doubt mechanisms could be devised, but if we're trying to look for simple solutions, you would have to have a very elaborate mechanism that would preserve the interest of the defendant all the way through.
Yeah.
Because it wouldn't be enough to say, well, you'll pay it back when they decide to sell and move to a different bungalow in 5 years' time. They still need another bungalow. So, well, as I say, this is slightly undisciplined of me to raise the point. I'm not going to say any more about it.
No, well, Lord, I think it's important to have taken your lordships to, because perhaps of the wide-ranging nature of this case and solutions which have been suggested in the past, simply to make the point that the parties have considered and agreed that these don't provide solution.
I'm very conscious that we're working with experts, and that's why I certainly wouldn't want to go behind this. I just wanted to understand it.
I'm obliged. Well, my lord, the last one I should mention then for the sake of completeness is in fact one we've already touched on, which is the whole question of shared ownership, and the point my Lord Justice Irwin makes that you would need to have certainly a charge. In effect, you would not be involved in unsecured lending and so on. So there are all sorts of complications which arise, we would say, which have led to those options being ruled out. So, well, can I move from there then to things which are not considered to be viable to what we say is an alternative to full capital value, potentially, in this case? And we have identified the option which we think is a viable one as the full capital value less the market value of the reversion in accordance with Mr. Watson's valuation. It might be sensible perhaps to look at the way in which we put this in the skeleton. I've so far not as important the format of the skeleton, but this is at page 68 in the bundle, paragraph 16. Where we start to deal with reversionary interests. Well, that just comes right after our discussion in the skeleton of capital value, which I've really summarised in the position I've just set out. As far as reversionary interests are concerned, we do think that this is a viable solution in this case and potentially in many others. And we would submit that our submissions in opening about this in our written skeleton have in fact survived contact with the evidence. Indeed, they've been strengthened by the evidence that your lordships and your ladyship have heard. So we say it may in fact offer a solution as an alternative to full capital value in a great many cases, as long, of course, as it's capable of practical and proportionate application at trial and in negotiations during the lifetime of claims. The sort of considerations that the House of Lords in Wales and Wales we've seen were referring to in relation to the operation of the discount rate when it was revisited in that case. Secondly, we say it should be capable of consistent application to all types of claims and claimants. And lastly, that it should enable claimants to acquire the special accommodation that they need. That, of course, is implicitly a way of saying that the gap which is produced by the application of a reversionary interest model should not, in our submission, result in an unbridgeable gulf between what practically the claimant is going to be able to afford, in most cases, and the cost of special accommodation. In other words, getting back to the sort of pragmatic outcome that was the position when this court was first dealing with the matter in Robertson Johnston. And we do say that, again, if those requirements aren't capable of being met by a reversionary interest model, which we suggest that they may be, then we would fall back on capital value. So as far as reversionary interest is concerned, your Lordship, your Ladyship really have, in a sense, a bifurcation of the evidence in relation to this. There are two things which arise. One is the question of a simple market value being attributed to the reversionary interest and that being deducted, and the other is a more nuanced approach which tries to identify what has been termed a fair and reasonable value of the reversionary interest. Fair and reasonable, of course, is a bit of a misnomer in this context, because it's fair and reasonable on the evidence that the Lordships and Ladyship have heard, in relation to rather different circumstances where the interests of the parties are equally balanced.
Let's be clear about this. What we're talking about is that both methods of valuation, they're just different methods.
Yes.
One takes a method from a evidence about a market.
Yeah.
The other approaches it in the different way described by Mr. Robinson. Or indeed as his unpreferred alternative by Peter's witness, whose name for a moment has slipped my mind.
Mr. Watson.
Mr. Watson, thank you. But they are both valuations of a notional reversionary interest, not actually a reversionary interest which it is proposed would be granted. I notice at 16.1 in your skeleton you talk about the valuation or grant of reversionary interest.
Well, yes. I mean, it's in the nature of the proposal that there could be a grant of reversionary interest, but I agree with respect that what we're actually talking about is a way of arriving at a valuation which would represent the value of the reversionary interest.
Or a reversionary interest if granted.
Reversionary interest, that's right.
Yes. That's fine. It's just that at various points in your skeleton, I got the impression, but it didn't really come out in any of the evidence, that you were contemplating in some circumstances a reversionary interest might be granted, and I wasn't quite clear how that would be done. We'd get into the sorts of difficulties that we exposed when I asked you my questions earlier. So, but if we're not going there, I needn't say any more about it.
Well, my Lord, what we do say is that if the court were adopting a market value approach, in other words, Mr. Watson's approach based on what the market would pay on the basis of an expected yield is 6.6%, then the valuation that you get is potentially a valuation which would allow the claimant to sell the reversionary interest. And if that is the case, then that would provide a solution in a great many cases, because if, for example, one goes back to the example I gave of a very short life expectancy, in which it might be unpalatable, for obvious reasons perhaps, for the claimant to receive the full capital cost, additional capital cost of purchase, the claimant would face a deduction representing the reversionary interest of a very substantial amount, but if that had been arrived at by reference to a true market value, then the claimant would, at least in those cases, those difficult cases, even under Roberts and Johnston, have the potential ability to sell the reversionary interest.
Mr. Sweeting, how would that potentially work? You say you've got a 5-year life expectancy.
Yes.
For somebody who's been renting. So you've got a whole purchase cost. Call it $1 million, doesn't matter. The claimant would have to have title to the house. The reversionary interest would be a very substantial proportion of the house and therefore the award.
Yes.
If you were to have an actual market, the claimant would sell it, but presumably there'd be an obligation to return that money to the defendants. Until until the market was tested, nobody would know what the return would be on it, and therefore what the debt would be. There would have to be a charge, and what if nobody wanted to buy? So there are a whole series of problems wrapped up in that we can't possibly resolve on the evidence before us, I suggest.
Well, Lord, I'd agree that your lordships and ladyship are not in a position to resolve that. We are simply saying that if one adopts market value as the starting point, it remains the position that it may be possible for claimants in those difficult cases to bridge the gap. And if we are starting from the position that the defendant is paying less the reversionary interest, then the claimant is in a position to sell the reversionary interest and fund the property, which the claimant wouldn't otherwise be able to do. So in the example your lordship has just given, a substantial amount is deducted, as a result of which the damages which the defendant has to pay are reduced considerably. But in order to fund the purchase, that's the point I'm really making, and that might have been the step I didn't explain, the claimant would be in a position to go and get the additional funds that are needed from the market, because the gap which had been left by the deduction from the damages would actually be a gap which, in theory at least, and this is the closest we could get, is what the market would pay for the reversionary interest.
But that goes only so far as this, that one would be, assuming we're able to go beyond Robertson Johnson, one shouldn't say anything which precludes that being negotiated in a given case in the future.
Yes.
That's about as far as we could possibly go in.
Well, that's right. It's one of the reasons, though, for favouring the market approach. It's not the only reason, but it's one of the reasons for favouring a market valuation. And we heard in the evidence today from Mr. Watson, both in chief and then in re-examination, he amplified that evidence, that although the market was small at the moment, there would potentially be a market for claimants to sell reversionary interest. There's no reason why that shouldn't be the case. And so if that's right, it would potentially be a solution in a great many cases if the claimant had received less than was necessary, couldn't bridge the gap from unallocated damages, and was in a position to sell a reversionary interest in the property. So we simply raise the spectre that if you have a market valuation as your starting point, and that was why Mr. Watson was saying, yes, the market would accommodate this. There would be people who would invest. There are those very difficult cases we've all come across, the 2 5-year life expectancies where there's no possibility of renting, one has to buy, and in those circumstances there is at least the prospect of a market in which a reversionary interest could be sold to bridge the gap. And the gap, importantly, would be a gap which was a market value gap, so it would get as near as one could to representing what the reversionary interest was likely to raise based on the sort of yield that an investor would expect. So that's the way we put it. I appreciate that, and we agree with respect that what the court should be trying to do is come up with a practical solution which attributes a value to the reversionary interest. And we say one of the attractions of market value is that it's a real, it's not the only one, but it's a real valuation based on the evidence that is before the court today from Mr. Watson.
The route you've just been outlining would be available if the court's principle was fair and reasonable valuation as well. You would say there would be simply there would be a greater risk, but it wouldn't match what, if the claimant did try to sell, they could actually get for the reversionary interest.
Yes, that's precisely the point, my lord.
It's very hard. Well, and I suppose you say that it is inherent in the nature of the two valuations as described. It really depends what findings we make. That the market value is likely to be higher, is inherently likely to be higher than the fair and reasonable valuation. If that's not the case, isn't a problem?
No, I think it may, perhaps I misheard that. It may be the other way round. I think that people's submissions make the point as well that the market valuation of the reversion is likely to be less than...
I'm sorry, I may have misspoke, but yes.
Yes.
So there's inherently likely to be a gap because of the nature of the two exercises.
Yes.
That's what gives rise to the problem. And you say there is inherently likely to be a gap, and that's what comes out of the evidence.
Yes, exactly. And indeed, market value, of course, fair and reasonable, really takes into account on the evidence you've heard this concept that there's a marriage value to be attributed, and it arises in circumstances where what the valuer, the actuary, is trying to do on the evidence is to balance the interests of both parties. And you will appreciate that a lot of the cross-examination was designed to elicit the obvious point that that is not the starting point in a personal injury case. And indeed, it's not even the starting point in the setting of the discount rate, where a prudence allowance has to be made in favour of the claimant. And the same is true that if one is dealing with the question of whether or not one should be balancing the interests of the claimant and the defendant, that we would submit is the wrong starting point. It is the claimant who needs to be fully compensated. If the best evidence that the court has is market value, then that represents a proper compensation for the claimant without any adjustment to take into account fair and reasonable or marriage allowances and so on. Marriage values.
And one other point, I think my lord is far ahead of me, but I'm just thinking about myself. In the position as it is at present, and obviously things could change in X years, perhaps as a result of our decision, but in the position as it is at present, because the market is so small, the court really has no option but to take a figure for the value. The court can't require the parties to test the market, because you'd have to go out and find a house, and then you'd have to find out whether before you bought it there was someone who was willing to buy the reversion at a price that made the difference between that and the damages that were available. And that's just not the practical world. The possibility of the claimant selling the reversion only emerges when there is already in place a very robust valuation, a very robust market, so the court is able to say, well, I can tell you now, we can work out what the market value of the reversion is. May have to be some evidence, but it's no different from having evidence from an estate agent in another case. Is that right?
My lord, it is right, and we're not suggesting that what the court should effectively do is say, go away and in each case obtain a surveyor's report, actuarial evidence, and so on. The solution we suggest is that the court does have evidence as to the market yield that's expected from Mr. Watson. That's the only evidence about market value. All that the court has in relation to fair and reasonable are illustrations. Nobody has done a fair and reasonable assessment in relation to the claimant's property. And what is required is a methodology which can be operated from case to case. And I think what you have in the format of, in fact, one of the very first documents we introduced into the evidence in the form of the table produced by Mr. Dakin is a summation in tabular form of what happens if you take the yield, and indeed other yields. You take the yield suggested by Mr. Watson, that's his evidence as to what investors would expect, and you apply that as a calculation to the facts of this case based upon the discount rate, so it factors in life expectancy and so on. So that's an operable formula for producing the calculation from case to case, and it is based on evidence. And you will recollect when Mr. Dakin was asked about this, well, is this a robust market? Is Mr. Watson's evidence about this based upon a deep and liquid market or a robust market? He said, well, it's yes. His answer was yes. And then he said, well, if you require a mortgage valuation, you would accept 3 mortgage valuations. Mr. Watson has described the market and he has given the evidence. In fact, the examples he gave really bear out that the yield is around about 6% that the market would seek to get. The yield is not affected by lifetime. That's taken care of in the rest of the calculation. That simply produces a higher or lower price in the way in which Mr. Dakin has set out in the table. And my lord, and we say that if one takes what Mr. Watson has identified as a market valuation and uses that as the methodology in the way in which it can simply be set out, as Mr. Dakin has done, you do produce a sensible valuation of a reversionary interest case by case. We can see that it changes according to whether it's a short lifetime case or a long lifetime case, but in a case such as the present, it would in fact produce a pragmatic solution to the problem, and it could be applied in every case.
Mr. Sweeting, would this also be the case that there is presently a small market, but Mr. Watson clearly did not rule out the possibility, if there were a change following this case, of a bigger market coming, driven by PI claims? What would be envisaged that as the market developed, so there were more figures, so, if you like, a more robust market, so that it might be possible in the future for this particular methodology to be revisited in the light of up-to-date evidence?
My lady, exactly. It certainly had occurred to us that there might be occasion on which to revisit any view that was arrived at on the basis of the market value evidence we have today in the light of the development of a market, which Mr. Watson was plainly anticipating was a possibility.
And you're not thinking of a change to the methodology, as I understood it. You're thinking of looking at a bigger, better body of evidence and saying, well, it shouldn't be 6.6, it should be 5.7 or whatever, but keeping the methodology but developing the figures.
My lord, precisely. And of course, if that was the case, it would be evidence of a real market which claimants could have access to. So it would be the best evidence your lordship, your ladyship have at the moment as to market valuation is from Mr. Watson. You don't in fact have any evidence about fair and reasonable, and it's difficult to see where one would set, as it were, the intermediate option, and it's equally difficult to see why you would do that in the first place, because this isn't a case of trying to even the position between claimant and defendant. And what the claimant should be entitled to is a deduction of no more than the real market value, because that is the value that, on the evidence you have, the claimant could obtain for that reversionary interest if the claimant went to the market. And as my ladyship says, if a market develops, the data around that would simply become more accurate and more granular as one goes forward, but it would still retain the integrity of being an amount which the claimant could go to market and get. We are starting from the best evidence in relation to that at the moment with Mr. Watson, 6.6%, and that data might improve over time. And it would be open to my department to say.
This would mean that Mr. Watson, who would be kept pretty busy, would be being called to give evidence pretty often. There would be no room for anyone else, because the market, as I understand it, of course things might develop so much that other players came in, but for the time being, everybody goes to Foster and Cranfield to sell these sorts of odd property interests, and there is no one else offering that service. That's an odd situation, and he actually makes the point, I can't guarantee Foster and Cranfield will stay in business.
Well, he's coming to retirement, and after today, he might, leave more quickly than he otherwise would have done. But could I ask a question about the application of market value?
Yes.
Taking on board that you say all you've said, is there not at least one significant difference between the purchaser of a reversionary interest in the open market, who will pay tax, and the value to the claimant, who will, broadly speaking, be very unlikely to pay IHT on an adapted home. And that can be quite a significant difference. And Mr. Dakin, I don't think Mr. Watson didn't actually factor that in when reaching the 6.6%.
Isn't the answer, my lord, that he said that the tax position of purchasers might vary enormously as between purchasers, and it simply wasn't possible to really take that into account?
I think he said that in relation to income tax, on the basis that the tax position had to be taken at standard income tax. But I think one of the points that the respondent has made, that the appellant has made, is that the respondent has made, is that broadly speaking, investors are going to pay IHT on any transfer. They're going to pay capital gains. There will be a tax regime in relation to the transfer of capital, whereas broadly speaking, claimants will be IHT free. It will certainly be capital gains free because this is their principal residence. So I don't know whether you're going to address that, but there may be broad factors, even if one accepted the market model, as to how it required some adjustment.
Well, Lord, I confess I wasn't going to address that specifically, but the point about the market model is that we start from the position which is the respondent is really advocating. If you look, for example, at the calculation of the reversionary interest which was performed by Miss Angel, we get to 1.3 million for a property or an interest in property which is of 900,000, and it's simply unrealistic to do that, but that is the result of making assumptions about house price inflation and general inflation and just following that arithmetical model. And the problem with that, apart from the fact that it produces this bizarre result, is that it just basically says that the claimant is taking the risk in relation to all of that. The point about a market valuation is that factored into the yield is all the risk and the cost that the market is prepared to bear. So instead of the claimant having to take the risk of all those externalities, the market does. And that is why you expect a yield of 6.6. And we can realistically expect that if that is the yield that the market wants from an investment in a reversionary interest, that both cost and tax and risk associated with life expectancy and so on have all been factored in. That is the purpose of a market valuation with an expected yield. It will be the same with the property investment.
Well, thank you. I didn't mean to divert you even.
I think I've started this running by asking some rather naive questions, but at least I think it has enabled us to get into how this would really work, which I at least have found very helpful. That I think will be a natural time for us to take our break.
Oh, yes.
Let's sit again at 3:25, or according to my computer, which now says it's 3:18. That'll just give us a short break. Thank you.
Don't worry, it's okay, you don't have to do anything like that, promise. You just sit tight. Okay. I'm just going to stand up because my back's going to go if I don't. You need to switch that off.